SJC-13460, Bristol Asphalt Company, Inc., v. Rochester Bituminous Products, Inc.
Good morning, Your Honors. Michael Rabia on behalf of the appellants, the defendants in the case below, Paul and Alberto Tedesca and the Rochester Bituminous Products Corporation. I want to distinguish briefly between the my three clients. The Tedesca brothers.
Could you rewind? Do we really need that? Because you've done that well in your brief.
Okay, thank you. I'll move on. So as the court knows, my clients were involved with other parties in challenging certain approvals for an asphalt plant that's proposed to be sited in Rochester. Their co-plaintiffs included Michael and Carol Daci, who own a property right next to the proposed site. Those challenges to date have all failed. I note, as does the appellee's brief at, I think it's page 17, that there is still a pending challenge to that. So to the extent this court retains the second path, the second stage.
Yeah. Can we start with the first path of the second stage? Because you've got three very sort of insightful, detailed opinions by the appeals court, but I'm still not sure what the law is and what it should be on that second path. So can you the first part of the second?
Right. Yeah. So once, as is done, there's no dispute that this is only about petitioning activity. There's no dispute about that. The question is, did the plaintiffs below show that my client's petition activity was sham or devoid of any reasonable basis in fact or arguable basis in law? And you know that I think is that's the question. It's the statutory question.
And we do that count by count, right? We don't look at the case as a whole, right? We look at each legal count and decide whether it's devoid of, I mean, everyone agrees that everything is based on petitioning activity. So prong one here is satisfied. Prong two, we're dealing with the fact, but we analyze prong two count by count, right?
I think that's not entirely clear to me, at least, Your Honor. Because
and that may be one of the things we need to clarify.
Right. If we were simply focusing on whether or not the complaint is based on petition activity alone, there we go count by count. There's not a doubt about it.
But shouldn't we go count by count on the second part of this as well?
That becomes difficult because I guess this is one of the questions that the court solicited amicus briefs on. How much sham petitioning activity suffices? Does the non-movement have to show that all of the petitioning activity was sham? I mean, that is one of the questions.
But like in this case is very good because we've got multiple counts, but at least the dissent in this case says, okay, one of the counts has one basis for support. I read the dissent as also saying that the other count should be dismissed. I mean, should not have been dismissed. It's just that one count that's saved.
I don't know whether I think I understand
and if I'm not clear, this stuff is incomprehensible. So say so.
No, I understand the brunt of the question, but I'm not sure. I'm not sure that the complaint filed by my clients, or at least the Tedesca Realty Trust, not Rochester Bituminous Products, whether the complaint filed in the land court tracked everything on a count-by-count basis. I believe there's a commingling of things. So I guess
well, isn't the test whether the petitioning activity had a reasonable factual basis in law or fact? Right? Isn't that the test? So don't we necessarily have to focus on the petitioning activity regardless of how the plaintiff decided to allege it in their count-by-count analysis?
Yes, I think that's a better approach. It's the petition activity. And here, you know, there are three phases of petition activity. I mean, one of the questions, the statute very clearly says that the non-movement, in order to defeat a special motion, has to show that the petition activity is devoid of reasonable factual basis or arguable basis in law. And that's any. You know, it's very clear. It doesn't. There's not like a weight. There's not a weight. And I recognize that might lead. You know, you could have a case where a small portion of petition activity is.
But this is an exceptional remedy to give someone, you know, to grant this motion to dismiss. You get attorney's fees. You do this in a expedited way. Don't we? I mean, I understand if we do it count by count, but if we're just sort of, looking, is there anything left there, then you dismiss the whole thing? I mean,
Well, I'm going to try to start with what I consider relatively low-hanging fruit. I think if we distinguish between the three phases, so we have the phase where my clients challenged site plan approval, then there was the phase where they challenged the extension of the order of conditions issued by the Conservation Commission, and then MEPA review. I think those can be clearly distinguished. You could conclude that one phase was not sham petition activity, and other phases were. That's a perfectly viable option. But I want to focus on the site plan approval phase because that was the phase that Justice Englander focused in on as involving legitimate petition activity, at least with respect to traffic impacts. I would argue that the three main issues that were resolved by the trial court, which involved noise, traffic impacts, and proper reduction values, I don't think any of that was sham. So far, the courts below have not agreed with me. It's only Justice Englander with respect to the traffic impacts has argued that was legitimate. And I think he's absolutely right about that. And I don't need to belabor that argument. I make it very clearly in my brief, and I think Justice Englander does a very good job of showing how the trial court really weighed competing experts' testimony and looked at the applicable bylaw in order to conclude that the plaintiffs were wrong on that count. But that doesn't mean it was sham petition activity, just that they were mistaken. On the noise impact issue, I would argue that that was decided on summary judgment. I understand that. And so there was no trial evidence issued. No trial evidence entered on that count. But on the noise impact, we had my clients had an expert showing that it was going to exceed the permissible threshold. And the reason that count was deemed was the reason they lost in summary judgment was because your
expert made an assumption based on facts that the other side said were not reasonable.
No, I think in this case on the noise issue.
No, I'm sorry. I thought you were talking about the traffic, the 6 trucks.
No, I was right. I was focused on the noise issue there.
But on the noise issue, that was deemed unreasonable because that was a condition precedent to the issuance of the approval. So if I tell you you can't go over X amount and you haven't demonstrated they've gone over X amount, but in order to get the approval, the applicant has agreed with that. I mean,
right. Well, okay. I'm gonna turn to the particular bylaw provision at issue, and I believe this is at page 370. I'm sorry, bear with me just one second.
But can I add to Justice George's point, which is, isn't there a DEP requirement on that? They're going to have to get sign off from the DEP on that noise, right? Or am I confusing that with a different part of this?
No, you are correct. But
that's what the land court says. The land court says, look, you got to get the DEP to sign off on this, and they're not going to sign off on it if it violates that.
That provides a basis for entering summary judgment against my clients. But the fundamental question here is, was the complaint, insofar as it's based on noise impacts, was it sham petitioning? And I would turn to...
But it's not the word sham we've added again, but the word is devoid of any reasonable factual support or arguable basis in law. Isn't that devoid of any arguable basis in law?
I would disagree, Your Honor. The particular bylaw provision is at page 459 of the record appendix, and it says that a project must conform with state and local sound regulations as amended from time to time. The regulations, as issued by the DEP, require that there be that sound can only increase 10 decibels above ambient noise. Okay, so if you're looking at this, you have a bylaw provision that doesn't say, it just says it has to comply, and there was no dispute. It has to conform with the state regulations. There's no dispute that before the land court, the project proponent had not demonstrated compliance. I concede, I agree entirely that there was a condition imposed, but I don't think that if you look at the bylaw provision, I think it's arguable that there could be a reasonable interpretation, an arguable basis in law to say, no, it's not just enough to rely on a condition in the approval. They actually have to go further than that and demonstrate that. At least I think that's an arguable basis in law as to why I think the noise impact claims were not sham petitioning.
But you don't even, in your view, you don't need that to have your special motion allowed, right? As long as you had any argument, and again, I'm not sure that's what the dissent is saying, because it seems like the dissent was pruning what was going to happen, but your view is, right, that if you have if anything, if that traffic thing was enough, the motion to dismiss should have been allowed, right?
Yes, that is my argument, but I don't want to rely only on the traffic impacts. I also want to argue that the noise impact argument and the property value reduction argument, those were also legitimate arguments. There were other arguments
Well, counsel, that implicates one other thing that Justice Englander brought up in his dissent. Could you touch upon what you think the standard of review ought to be?
Well, certainly de novo standard of review, for the reasons articulated by Justice Englander, because the question...
Have we said that? Have we said that?
I don't believe this court has.
In fact, we've said that it's abuse of discretion, clear error of law.
Right, and I think as the amicus brief...
By the way, can I just frame that? Because from what I understand, Judge Englander is saying we only said abuse of discretion, clear error of law in the context of the new second part. Is that, or have we said abuse of discretion, clear error of law for the old first part of the second part?
I think the amicus brief submitted by the New England First Amendment Coalition says that the court has been unclear in articulating that standard.
But isn't it have to be de novo? I mean, doesn't it have to be de novo? Because we're looking at, all we've got are affidavits and legal argument at this stage of the process. So doesn't it have to be in the de novo review?
I agree entirely, Your Honor. Yes, I think it has to be de novo review. Yes.
I just don't understand how you could do it, and I also don't understand how it could be preponderance. Is that also confusing? Because how do you do a preponderance standard based on affidavits and legal issues? Is that also something we have to clean up because it doesn't make any sense?
Well, it's what this court articulated in the Baker decision, and the New England First Amendment Coalition argues for the retention of that standard.
How do you do it, though? So how do you do, maybe I don't understand the subtlety. How do you do a preponderance review based on affidavits and at this preliminary stage? Because preponderance to me seems to be more something you do after a trial.
Well, my case may not present that question in the cleanest form because my case involves, trial has actually happened. Trial happened and decisions have been issued. So this is all retroactive. And in a sense, I think you can apply preponderance of the evidence standard to my particular case. Going back earlier, if it's a typical case where the case is suspended pending the resolution of the anti-SLAPP motion, I'm not sure how one would address that.
But if you're arguing for a de novo review of the, and I can't say this, so I'll just say, of the reasonable factual basis and arguable basis in law prong, right? That's a de novo review.
Yes, Your
Your
Honor,
position.
yes.
How could the court on appeal apply preponderance of the evidence standard on that? If it's a matter of law, it's either right or wrong. It's not more likely right or more likely wrong.
Yes, that is true. I mean, I was focused more on getting away from an abuse of discretion standard and just deferring to the trial court decision.
So assuming that we're with you there, it's de novo, then doesn't necessarily, it's de novo because it's an issue of law, right?
Yes.
Yeah.
Yes.
And so a preponderance of the evidence standard doesn't necessarily make sense if we're determining things as a matter of law.
Well, some of the testimony will be affidavit. I mean, some of the evidence will include affidavits.
Right, but that's what we're going to get is we're going to have affidavits for facts, not credibility findings, because there are going to be no findings at that point. And so we're going to have to look at what the submissions are. Is it more like a summary judgment standard? Because, I mean, you've got affidavits and on the traffic, for example. Had they not submitted a traffic expert, then this is clearly without a reasonable factual basis. But you do submit a traffic expert, so you've submitted something. I just don't know what the standard we look at. I mean, if it's preponderance based on affidavits, and it's a de novo review, I mean, and this is our fault, not yours, but I'm just trying to understand what we're saying.
Well, I think Justice Englander's discussion of the traffic analysis that the land court undertook provides a reasonable example. We have competing experts, and I guess the key thing is to remember on whom the burden lies. The burden lies on the non-movement to show by preponderance of the evidence. So it has to offer more evidence than the moving party has offered in order to carry its burden. So I don't think that particularly helps you in wrestling with this issue, but I do think that Justice Englander's analysis provides...
The court's analysis looks at this as a whole and says, okay, I find the traffic stuff very weak, but the other stuff is really, really weak. And therefore, I can determine that the petitioning activity is without reasonable, basis in fact or law. It's also carefully done. And she's basically, Justice Hand is basically saying this just doesn't rise to the level of legitimate petitioning activity. Again, this sham thing is terminology we've added, and it makes sense in this part 2, the second part of part 2, but I'm not sure it's relevant to part 1 directly. You don't need to prove a sham. You need to prove that it's without a reasonable basis in fact or law, right?
And now that, as I'm thinking through this now with your help, the arguable basis in law, I'm not sure how an evidence standard at all applies there. I mean, if it's an arguable basis in law, I'm not sure.
Well, you've got to allege facts that, claims have elements, right?
Yes.
If you don't put in affidavits to support an element of the offense, you lose, right? You haven't.
That is correct, yes.
That's why I'm wondering if it's more like a summary judgment standard.
It depends on what one means by a summary judgment standard. If it's the case that, that as long as one side raises a dispute of fact, therefore summary judgment can't enter, I think that harms the movement, the originally petitioning party, too much. I think the Baker decision tried to strike a balance, recognizing that someone's petitioning activity is going to be short-circuited, so to speak. And I do not have an alternative to suggest to preponderance of the evidence, although I recognize that it is...
What about a prima facie showing of some sort? Because the word is show, right? Again, I'm trying to get back to the statute, because at least the statute, this thing should be moored in the statute. So the moving party's exercise right was devoid of, maybe it doesn't have a showing. The moving party's exercise of its right to petition was devoid of any reasonable factual support or any arguable basis in law.
Right, and the non-movement does have to show that. That's what that language is clearly in there. So I think
But how is that helped by the preponderance of the evidence standard? That's my struggle. So just take the traffic issue. So you give evidence of what you think the queue is going to look like if these trucks come in, and if it's more than 6, they'll spill out onto the road. And then there is competing evidence that's presented to the judge that, hey, a lot of these trucks are our trucks, and we have the ability to kind of, fix that problem by coordinating who comes when. Now, if the standard is reasonable factual basis, right, the factual basis part, and that's informed by the quantum of proof of preponderance of the evidence, more likely than not, right? So if the judge in this case found that the non-movement sustained their burden, and say it was 51-49%, does that mean that there's no reasonable factual basis?
And when you say the judge, you're referring to the judge that denied the special motion, or the land court judge? Okay. Under the preponderance of the evidence standard, I think that would follow if the judge decided 51 to 49%. I mean, that follows from the language.
Right.
I think that, and I recognize that that's a.
How do you do that based on affidavits?
Yeah.
I just don't understand how, I mean, you're not making credibility findings. I can see you can make a determination that you haven't alleged facts that satisfy an element of the offense, of the claim, but I don't know how you can do weighing of evidence like 5149. I don't know how you do that in this context. Is there anything, it seems like we're doing something more like, frivolous litigation up front. We're trying to make a determination of whether the litigation or the claim is frivolous, but we're doing it at a preliminary stage of the process. The only thing that comes to mind is the housing bond thing we did last year, which has an element of that, where you're imposing a bond based on the fact that the thing clearly has no merit before you've done all the fact finding.
The Liz Pendon statute, too.
Yeah.
Right. I wish to God I had some helpful words and some approach to resolve this dilemma, but I don't accept to fall back on what has to be shown. It has to be shown by preponderance of the evidence that it's devoid of reasonable factual support or arguable basis in law. And I think in our case, I just do not think that the plaintiffs, the non-movements, met that burden.
Okay.
Thank you.
Thank you. We're going to ask Attorney Hurley to give it a whirl.
When I came here this morning, I thought I had this pretty well in hand, but obviously I do not. I understand the conundrum of what the burdens are, but just to give a little background.
So before you give the background, can I just dive right into anti-SLAPP? I'm sorry, we're all anxious to do it because we ask the questions of the public and we've got all these amici. So let's just get going.
I understand.
We understand the facts in this particular case, but on anti-SLAPP itself, isn't the determination whether something has a reasonable factual support or arguable basis in law a de novo determination that's a matter of law? What is the argument even that it's not?
I don't think there is a good argument.
Okay, so
frankly.
we all agree with Judge Englander that it's de novo, right?
I think that's the better approach.
Okay, so if it is a matter of law, how can you possibly determine that on a preponderance of the evidence?
I'm not sure I understand the question.
Well, I mean, I think we said in Baker that determination of whether something has, the petitioning activity had reasonable factual support or arguable basis in law, which you agree with me is a legal question.
It is a legal question.
How can that be determined based on this overlay of a preponderance of the evidence analysis?
I'm not
Either
sure.
is legally correct or not.
Isn't it a mixed question of fact and law, though? Because
I
you
think it
got to
is.
look at the affidavits. Say the law is obvious. The permitting, there's a clear requirement, but you haven't put in any facts. Then you haven't put in a fact on an element. I'm thinking more in the criminal context, but it works here too. You haven't submitted any factual affidavits on a necessary element of proof. You lose, right? That's not preponderance of the evidence, but it's a mixed question of
Right.
fact and law.
Ordinarily, that would be the case, yes.
Yeah.
So let's look at this case. So we had three different kinds of petitioning activity, and I'm not sure how it applies to each. Maybe it's different to each. So
Well, let's take the traffic
okay,
situation.
but in that case, we had the benefit of a trial.
Yeah, the benefit of the trial. It had to go to trial. Why isn't there enough reasonable basis that the traffic situation might be, as their expert said it was?
We went
The
to
law, I mean, they lost,
We
but-
went to trial, I think, frankly, because we thought it was faster to go that way. It wasn't any great intellectual, any great intellectual decision to do it as opposed to summary
Well, I mean,
judgment. I mean, I was there.
regardless, there was an expert that they presented who said that there was going to be a traffic problem. Why isn't that enough to show that this has some legs.
Part of the problem with that is if you read the whole transcript from that trial, later on in his testimony, when I cross-examined him, he admitted that that really wasn't clear. And so
What wasn't clear? What
that it was going
specifically?
to create a problem. And so I think the judge.
So because you on cross-examination were able to get the expert to
back off
of his original opinion, it denies the petitioning activity of these particular defendants?
Well, it makes it sham.
Why?
Because they
Why
didn't
does
have-
it-
because they
Did you
didn't
get
ha-
the expert to say that they told me to tell you this, that they paid me for my opinion?
I don't think we need to do that to prove a sham, do we? I mean, if you bring on an expert and he gives a bogus opinion and that gets demonstrated on cross-examination, I think you still can
So
fall.
anytime you get on cross-examination, you get an expert to flip, it's a sham?
It's the time of the petitioning activity. It's the time of the petitioning
Right.
activity.
And the
Be
petition,
analyzed.
the time of
Not
the,
the cross-examination at trial.
well, at the time of the petitioning activity, there was no good faith basis for them to
Well,
bring that
didn't they
petition.
have the opinion of the expert?
At that time, I don't know, Judge, that probably came
Wouldn't you
later
have to
if I
show
had
that they
to.
didn't?
I'm sorry?
Wouldn't you have to show that they didn't at that time
That they
in order for
didn't
the
have it?
petitioning activity to be a sham?
That would put an awfully big burden on the moving party to do that, wouldn't it? I mean, how can we possibly do that? So you have somebody comes along and they bring a lawsuit, they challenge the issuance of a special permit, they have no expert. So maybe it's a good tactic for them to never have an expert at the beginning because we can't
Well,
move
then
to
they'd have
dismiss.
no reasonable basis.
Yeah, they
in
have no
fact, or law.
expert, it's
Then they'd
easy.
be in a worse position.
Right, I suppose that would
They
be
have
the
no
case.
expert, then you should win the special motion to dismiss. But if they do have an expert that has some traction that meets the I don't know if 6 trucks meets the definition, and that seems to be what the appeals court said, that, okay, it's sort of like minimal analysis. But then the appeals court looked in the whole context, right? It looked at, okay, so they brought, and that's what I think Judge Englander was doing at the end, is saying, okay, some of this I agree is just nonsense, but there's something here, and therefore the entire motion to dismiss should have been allowed. I'm not sure I follow that, right? Is if you prove that two of the petitioning things were nonsense, but one had some merit, do you still think the special, what's the answer then?
I have a hard time with that myself, that conclusion. I mean, I think he was wrong. Obviously, there's some disagreement about that, but I think he was wrong on the traffic issue. Because I think if you read the record completely, you would see that it was a sham based
But
on.
if he
That's not
was,
the question. The question is if he was, the hard question is if he was right on the traffic issue, but the noise was just a bunch of baloney.
That is a difficult question.
And that's what the appeals court majority is. The appeals court majority says, okay, two of the petition activities were such garbage and so without merit that this sort of problematic one over here isn't enough to save this. And again, a special motion to dismiss is powerful medicine. When you get a special motion to dismiss, you get attorney's fees, we short-circuit the trial process. Present execution, and it needs to be sort of cabined in ways that we can follow, right? But we need to clarify what the standards
The one
are.
point of disagreement I have slightly with
go
the
ahead.
judges, I don't know that the trial court, that the judge who issued the decision thought that traffic was okay. I mean, I don't think that.
But help us with the harder, I get that.
wait,
We
can
have,
I-
go ahead.
I'm sorry. Can you finish that last statement?
Sure. I mean, I think Judge Kafka's question to me was really about the appeals court decision, and they seem to think that that we had two, but I think the majority also thought that the traffic issue was bogus.
Right, so they didn't have to deal with Justice Kafka's scenario where part of the claim is bogus and part of it is not, as you say.
They eliminated that problem.
Right,
to
and
some
so the
extent.
harder question, which I think you said you don't have an answer to, and I just want to make sure because I want to give you an opportunity, is what if part of the activity is sham and part of it is not. Is the motion to dismiss allowed in part, or is it just denied?
Well, I think it's going to depend on every circumstance. It may
Well,
be-
let's say
it may be
here,
in some
let's do
it may
here
be in
then.
some
Let's do in
cases-
this situation.
it may be in
Justice
some-
Englander is correct that the traffic situation was not bogus. Motion to dismiss allowed in part?
You could do it that way. You could grant the motion.
I know I could, I'm just trying to
I'm
figure
just
out
thinking
if,
I could. Not
Well,
so
is that
much
what,
you.
Judge Han writes that, and for the majority, doesn't she look at it in, I can't remember, is the word in the entirety somewhere in the?
It is.
So they do, because that may be important to you to win here, right? Because we may conclude that the traffic thing has some merit, but agree with that the other two parts of this are nonsense.
And one could argue that you then should, in that odd circumstance that, which we may have here, that what you should do is look at the case as a whole in its entirety.
But that's why I was asking in the beginning, because often these things come up in different counts. And I understand why you would want to dismiss when the count is clearly nonsense. In this case, those three petitioning activities appear in the same sort of process, right?
Right.
So it's hard to sort of, but we often get cases like the next one that you're going to sit through if you stick around, where you have 6 different counts. And some of them may have no basis, but others have some basis. Then do we grant the special motion to dismiss for the entire case? That's what worries me. That's why I'm focused on whether we do this count by count or not.
I don't see as a practical matter how you can do it count by count. I mean, if I.
In your case, but what if they'd brought 2 separate counts? You know, a MIPA count and also, I don't know, you're an environmental lawyer.
Sure.
You know all these things. You've got all kinds of different things they can bring, right?
Yes, they could.
and
They could have. They could have done that. But what does it do for me? I'm just trying to think this through. I'm asking a question more than giving you an answer here. But so what do I do if I get a decision that says you win on 2 counts of your anti-SLAPP motion, but you lose on your
But isn't that the way
other?
normal litigation works? You essentially keep going and litigate the case as normal, which is that's why the anti-SLAPP is so complicated. But if you do it count by count, you win, you get your attorney's fees on that one, but they get to pursue the one that had a basis.
So you slap the 2
Right.
and you dismiss them,
Right,
and then the case goes on with the one that was determined to be non-SLAPP.
right. Isn't that the way normal litigation works?
It is the way normal litigation works, and maybe that's the solution.
Is that consistent with the intent of anti-SLAPP, though? Let it go forward?
I'm not sure that anyone who drafted the anti-SLAPP really had that in mind, that particular conundrum, so that we could glean any intent there. But that is a possibility, I suppose. I mean, I always thought of it in terms of the whole case as opposed to breaking it out by counts, because
of the intent of anti-SLAPP.
because from my client's perspective, we want it to be over because we think that it was inappropriately brought.
Because of the legislator's perspective, that the intent was it would be an anti-SLAPP if it involved petitioning activity.
I think there's a strong argument that would say
But isn't
that
there
that's.
another argument that says legitimate petitioning activity we want to protect, and we want to expedite the process to get rid of claims based on legitimate petitioning activity, but no one has any interest in illegitimate sham petitioning, and therefore we're not going to protect that kind of behavior. I mean, the legislature's not, parsing this. They're looking big picture. They're not parsing. They haven't thought about these, ripples.
Right.
And ripples and ripples that have come out of this.
Can I ask you a different question? So path, I guess the augmented Blanchard 1 path, second stage of the second prong.
Right.
If I've said that. What are your thoughts on that?
Let me start by saying, I didn't rely on that in our briefing because I don't think it applied to our situation. I think that's a very difficult part of the statute. I'm not sure.
A difficult part of what?
Difficult part of this, of the approach. I don't particularly care for it, the second prong of the second path.
Is there any statutory basis for it?
I don't think there is.
Okay. And is it required by the Constitution?
Is that path required by the
I
Constitution?
mean, my understanding of the Blanchard decision was that the motivation behind establishing and making up the second stage of the second prong was to protect the petitioning activity of the plaintiff, the non-movement.
Right, the non-moving party. Yes, it was. But that second piece of the second path of the second stage just simply says that you can have a claim that's, I'm trying to think this through.
So you can
here.
defeat the motion to dismiss if the intent of, we'll call the plaintiff here, the plaintiff was not to chill petitioning activity.
Yes,
Right.
yes, exactly. That's a difficult standard, though. I don't know how you glean that intent, but that second part, I think, is troublesome, frankly, even from my perspective. And I'm an advocate in favor of winning this anti-SLAPP motion. But
Why do you find it troubling?
I didn't rely on it because I think it's very vague as to how it works.
Because of its vagueness?
Yes,
Okay, and that has results on what, why is the vagueness troubling?
because I think it'd be difficult for a trial court to deal with.
Yeah,
I
it's
think
a-
what
it creates an
standards
upfront mini trial.
It would be a mini trial. I think that's exactly what the problem is. And we didn't rely on that second, I always get this, the second step of the second stage. We were focused on,
Gilbert and Sullivan.
we were focused on the first step. And I thought we met that under the existing case law. And quite frankly, just to go back to what I had intended to be my argument, I would say that, we properly relied on the first step of the second stage, and that, and I find Judge Inglis's dissent to be fascinating, but I think he was wrong on that aspect of it. I
So
mean,
you think you can have petitioning activity that has a reasonable basis in fact or arguable basis in law, so it passes prong 1 and prong 2 first step, and yet it can be, it can continue to go on because the intent of the plaintiff is not to chill activity? Or you're just completely abandoning the second?
I'm abandoning the second completely.
Thank you.
And I think I would if I were this court.
Well, you're joined by all the amicus as well, so.
I've read the amicuses, and
Nobody-
I came away from that experience thinking to myself, boy, these people know a lot more about this than I do. But I'm just a humble trial lawyer trying to make my way in this world. So I think the decision by the Superior Court judge was correct. I think the two judges of the appeals court got it right. I fully understand some of the good points of the dissent, but as applied to this case, under the existing law, before you folks decide to change it or elaborate on it or explain it, I think under the existing law, we properly should have prevailed under our motion, and I would ask the court to affirm the decision and make any changes that you have in the law prospective and not as applied to our case.